Republic Act No. 1147-9. An act to prevent, prohibit and penalize terrorism, thereby repealing Republic Act No. 93-72, otherwise known as the Human Security Act of 2007, be it enacted by the Senate and House of Representatives of the Philippines, in Congress assembled.
Section 1. Short title. This act shall henceforth be known as the Anti-Terrorism Act of 2020. Section 2. Declaration of Policy. It is declared, a policy of the state to protect life, liberty, and property, from terrorism, to condemn terrorism as inimical and dangerous to the national security of the country, and to the welfare of the people, and to make terrorism a crime against the Filipino people, against humanity, and against the law of nations. In the implementation of the policy stated above, the state shall uphold the basic rights and fundamental liberties of the people, as enshrined in the Constitution. The state recognizes that the fight against terrorism requires a comprehensive approach, comprising political, economic, diplomatic, military, and legal means, duly taking into account the root causes of terrorism, without acknowledging these as justifications for terrorist and/or criminal activities. Such measures shall include conflict management and post-conflict peace building, addressing the roots of conflict, by building state capacity, and promoting equitable economic development. Nothing in this act shall be interpreted as a curtailment, restriction, or diminution of constitutionally recognized powers of the executive branch of the government. It is to be understood, however, that the exercise of the constitutionally recognized powers of the executive department of the government shall not prejudice respect for human rights, which shall be absolute and protected at all times. Section 3. Definition of terms as used in this act. A. Critical infrastructure shall refer to an asset or system, whether physical or virtual, so essential to the maintenance of vital societal functions, or to the delivery of essential public services, that the incapacity or destruction of such systems and assets would have a debilitating impact on national defense and security, national economy, public health or safety, the administration of justice, and other functions analogous thereto. It may include, but is not limited to, an asset or system affecting telecommunications, water and energy supply, emergency services, food security, fuel supply, banking and finance, transportation, radio and television, information systems and technology, chemical and nuclear sectors. B. Designated person shall refer to any individual, group of persons, organizations, or associations designated and/or identified by the United Nations Security Council, or another jurisdiction, or supranational jurisdiction, as a terrorist, one who finances terrorism, or a terrorist organization or group, or any person, organization, association, or group of persons designated under paragraph 3 of Section 25 of this Act. For purposes of this Act, the above definition shall be in addition to the definition of designated persons under Section 3E of Republic Act No. 1016-8, otherwise known as the Terrorism Financing Prevention and Suppression Act of 2012. C. Extraordinary Rendition shall refer to the transfer of a person suspected of being a terrorist, or supporter of a terrorist organization, association, or group of persons, to a foreign nation for imprisonment and interrogation on behalf of the transferring nation. The extraordinary rendition may be done, without framing any formal charges, trial, or approval of the court. D. International organization shall refer to an organization established by a treaty or other instrument governed by international law, and possessing its own international legal personality. E. Material support shall refer to any property, tangible or intangible, or service, including currency or monetary instruments or financial securities, financial services, lodging, training, expert advice or assistance, safe houses, false documentation or identification, communications equipment, facilities, weapons, lethal substances, explosives, personnel, one or more individuals who may be or include oneself, and transportation. F. Proliferation of weapons of mass destruction shall refer to the transfer and export of chemical, biological, radiological, or nuclear weapons, their means of delivery and related materials. G. Proposal to commit terrorism is committed when a person who has decided to commit any of the crimes defined and penalized under the provisions of this Act, proposes its execution to some other person or persons. H. Recruit, shall refer to any act to encourage other people, to join a terrorist individual or organization, association or group of persons proscribed under Section 26 of this Act, or designated by the United Nations Security Council as a terrorist organization, or organized for the purpose of engaging in terrorism. I. Surveillance activities, shall refer to the act of tracking down, following, or investigating individuals or organizations, or the tapping, listening, intercepting, and recording of messages, conversations, discussions, spoken or written words, including computer and network surveillance, and other communications of individuals, engaged in terrorism as defined hereunder. J. Supranational jurisdiction, shall refer to an international organization or union, in which the power and influence of member states transcend national boundaries, or interests to share in decision-making and vote on issues concerning the collective body, for example, the European Union. K. Training, shall refer to the giving of instruction or teaching, designed to impart a specific skill in relation to terrorism, as defined hereunder, as opposed to general knowledge. L. Terrorist individual, shall refer to any natural person, who commits any of the acts defined and penalized under Sections 4, 5, 6, 7, 8, 9, 10, 11 and 12 of this Act. M. Terrorist organization, association, or group of persons, shall refer to any entity, organized for the purpose of engaging in terrorism, or those proscribed under Section 26 hereof, or the United Nations Security Council designated terrorist organization, and N. Weapons of mass destruction or WMD, shall refer to chemical, biological, radiological, or nuclear weapons, which are capable of a high order of destruction, or causing mass casualties. It excludes the means of transporting, or propelling the weapon, where such means is a separable and divisible part from the weapon. Section 4. Terrorism. Subject to Section 49 of this Act, terrorism is committed by any person who, within or outside the Philippines, regardless of the stage of execution, a. engages in acts, intended to cause death, or serious bodily injury to any person, or endangers a person's life. b. engages in acts, intended to cause extensive damage or destruction, to a government or public facility, public place, or private property. c. engages in acts, intended to cause extensive interference with, damage, or destruction to critical infrastructure. d. develops, manufactures, possesses, acquires, transports, supplies or uses weapons, explosives, or of biological, nuclear, radiological or chemical weapons, and e. release of dangerous substances, or causing fire, floods or explosions. When the purpose of such act, by its nature and context, is to intimidate the general public, or a segment thereof, create an atmosphere, or spread a message of fear, to provoke or influence by intimidation the government or any international organization, or seriously destabilize, or destroy the fundamental political, economic, or social structures of the country, or create a public emergency, or seriously undermine public safety, shall be guilty of committing terrorism, and shall suffer the penalty of life imprisonment, without the benefit of parole and the benefits of Republic Act No. 1059-2, otherwise known as an Act amending Articles 29, 94, 97, 98 and 99 of Act No. 3815, as amended, otherwise known as the Revised Penal Code, provided, that terrorism, as defined in this section, shall not include advocacy, protest, dissent, stoppage of work, industrial or mass action, and other similar exercises of civil and political rights, which are not intended to cause death, or serious physical harm to a person, to endanger a person's life, or to create a serious risk to public safety. Section 5. Threat to commit terrorism. Any person, who shall threaten to commit any of the acts mentioned in Section 4 hereof, shall suffer the penalty of imprisonment of 12 years. Section 6. Planning, training, preparing, and facilitating the commission of terrorism. It shall be unlawful for any person, to participate in the planning, training, preparation, and facilitation in the commission of terrorism, possessing objects connected with the preparation for the commission of terrorism, or collecting or making documents connected with the preparation of terrorism. Any person found guilty of the provisions of this Act shall suffer the penalty of life imprisonment, without the benefit of parole and the benefits of Republic Act No. 1059-2. Section 7. Conspiracy to commit terrorism. Any conspiracy to commit terrorism, as defined and penalized under Section 4 of this Act, shall suffer the penalty of life imprisonment, without the benefit of parole and the benefits of Republic Act No. 1059-2. There is conspiracy, when two or more persons come to an agreement concerning the commission of terrorism, as defined in Section 4 hereof, and decide to commit the same. Section 8. Proposal to commit terrorism. Any person who proposes to commit terrorism, as defined in Section 4 hereof, shall suffer the penalty of imprisonment of 12 years. Section 9. Inciting to commit terrorism. Any person who, without taking any direct part in the commission of terrorism, shall incite others to the execution of any of the acts specified in Section 4 hereof, by means of speeches, proclamations, writings, emblems, banners, or other representations tending to the same end, shall suffer the penalty of imprisonment of 12 years. Section 10. Recruitment to, and membership in a terrorist organization. Any person who shall recruit another, to participate in, join, commit, or support terrorism or a terrorist individual or any terrorist organization, association or group of persons, proscribed under Section 26 of this Act, or designated by the United Nations Security Council as a terrorist organization, or organized for the purpose of engaging in terrorism, shall suffer the penalty of life imprisonment, without the benefit of parole and the benefits of Republic Act No. 1059-2. The same penalty shall be imposed, on any person who organizes or facilitates the travel of individuals, to a state other than their state of residence or nationality, for the purpose of recruitment, which may be committed through any of the following means. A. Recruiting another person, to serve in any capacity, in or with an armed force in a foreign state, whether the armed force forms part of the armed forces of the government of that foreign state, or otherwise. B. Publishing an advertisement or propaganda, for the purpose of recruiting persons, to serve in any capacity, in or with such an armed force. C. Publishing an advertisement or propaganda, containing any information, relating to the place at which, or the manner in which persons may make applications, to serve or obtain information, relating to service in any capacity, in or with such armed force, or relating to the manner in which persons may travel to a foreign state, for the purpose of serving in any capacity, in or with such armed force, or D. Performing any other act, with the intention of facilitating or promoting the recruitment of persons, to serve in any capacity in or with such armed force. Any person, who shall voluntarily and knowingly join any organization, association, or group of persons, knowing that such organization, association, or group of persons, is proscribed under Section 26 of this Act, or designated by the United Nations Security Council as a terrorist organization, or organized for the purpose of engaging in terrorism, shall suffer the penalty of imprisonment of 12 years. Section 11. Foreign terrorist. The following acts are unlawful, and shall suffer the penalty of life imprisonment, without the benefit of parole and the benefits of Republic Act No. 1059-2. A. For any person to travel, or attempt to travel, to a state other than his or her state of residence or nationality, for the purpose of perpetrating, planning, or preparing for, or participating in terrorism, or providing or receiving terrorist training. B. For any person to organize, or facilitate the travel of individuals, who travel to a state other than their states of residence or nationality, knowing that such travel is for the purpose of perpetrating, planning, training, or preparing for, or participating in terrorism, or providing or receiving terrorist training, or C. For any person residing abroad, who comes to the Philippines, to participate in perpetrating, planning, training, or preparing for, or participating in terrorism, or provide support for, or facilitate or receive terrorist training here or abroad. Section 12. Providing material support to terrorists. Any person who provides material support, to any terrorist individual or terrorist organization, association or group of persons, committing any of the acts punishable under Section 4 hereof, knowing that such individual or organization, association, or group of persons is committing, or planning to commit such acts, shall be liable as principal, to any and all terrorist activities committed by said individuals or organizations, in addition to other criminal liabilities he or she or they may have incurred in relation thereto. Section 13. Humanitarian Exemption. Humanitarian activities undertaken by the International Committee of the Red Cross or ICRC, the Philippine Red Cross or PRC, and other state-recognized impartial humanitarian partners or organizations, in conformity with the International Humanitarian Law or IHL, do not fall within the scope of Section 12 of this Act. Section 14. Accessory. Any person who, having knowledge of the commission of any of the crimes defined and penalized under Section 4 of this Act, without having participated therein, takes part, subsequent to its commission, in any of the following manner. A. By profiting himself or herself, or assisting the offender to profit by the effects of the crime. B. By concealing or destroying the body of the crime, or the effects, or instruments thereof, in order to prevent its discovery, or C. By harboring, concealing, or assisting in the escape of the principal or conspirator of the crime, shall be liable as an accessory, and shall suffer the penalty of imprisonment of 12 years. No person, regardless of relationship or affinity, shall be exempt from liability under this section. Section 15. Penalty for public official. If the offender found guilty of any of the acts defined and penalized under any of the provisions of this Act, is a public official or employee, he or she shall be charged with the administrative offense of grave misconduct, and or disloyalty to the Republic of the Philippines and the Filipino people, and be meted with the penalty of dismissal from the service, with the accessory penalties of cancellation of civil service eligibility, forfeiture of retirement benefits, and perpetual absolute disqualification from running for any elective office, or holding any public office. Section 16. Surveillance of suspects, and interception and recording of communications. The provisions of Republic Act No. 4200, otherwise known as the Anti-Wiretapping Law, to the contrary notwithstanding, a law enforcement agent or military personnel may, upon a written order of the Court of Appeals, secretly wiretap, overhear and listen to, intercept, screen, read, surveil, record, or collect, with the use of any mode, form, kind or type of electronic, mechanical, or other equipment or device or technology, now known or may hereafter be known to science, or with the use of any other suitable ways and means for the above purposes, any private communications, conversation, discussion or discussions, data, information, messages in whatever form, kind, or nature, spoken or written words. A. Between members of a judicially declared and outlawed terrorist organization, as provided in Section 26 of this Act. B. Between members of a designated person as defined in Section 3E of Republic Act No. 1016-8, or C. Any person charged with, or suspected of committing any of the crimes defined and penalized under the provisions of this Act. Provided that, surveillance, interception, and recording of communications between lawyers and clients, doctors and patients, journalists and their sources, and confidential business correspondence, shall not be authorized. The law enforcement agent, or military personnel, shall likewise be obligated to 1. File an ex parte application with the Court of Appeals, for the issuance of an order, to compel telecommunications service providers or TSP, and Internet service providers or ISP to produce all customer information and identification records, as well as call and text data records, content and other cellular or Internet metadata, of any person suspected of any of the crimes defined and penalized under the provisions of this Act. And 2. Furnish the National Telecommunications Commission or NTC, a copy of said application. The NTC shall likewise be notified, upon the issuance of the order, for the purpose of ensuring immediate compliance. Section 17. Judicial Authorization, Requisites. The Authorizing Division of the Court of Appeals shall issue a written order to conduct the acts mentioned in Section 16 of this Act upon a. Filing of an ex parte written application, by a law enforcement agent or military personnel, who has been duly authorized in writing, by the Anti-Terrorism Council or ATC, and b. After examination under oath, or affirmation of the applicant and the witnesses he or she may produce, the issuing court determines 1. That there is probable cause to believe based on personal knowledge of facts or circumstances, that the crimes defined and penalized under sections 4, 5, 6, 7, 8, 9, 10, 11 and 12 of this Act has been committed, or is being committed, or is about to be committed, and 2. That there is probable cause to believe based on personal knowledge of facts or circumstances, that evidence, which is essential to the conviction of any charged or suspected person for, or to the solution or prevention of, any such crimes, will be obtained. Section 18. Classification and contents of the order of the court. The written order granted by the authorizing division of the Court of Appeals, as well as the application for such order, shall be deemed and are hereby declared as classified information. Being classified information, access to the said documents, and any information contained in the said documents, shall be limited to the applicants, duly authorized personnel of the ATC, the hearing justices, the clerk of court, and duly authorized personnel of the hearing or issuing court. The written order of the authorizing division of the Court of Appeals shall specify the following: a. The identity, such as name and address, if known, of the person or persons whose communications, messages, conversations, discussions, or spoken or written words are to be tracked down, tapped, listened to, intercepted, and recorded, and, in the case of radio, electronic, or telephonic, whether wireless or otherwise, communications, messages, conversations, discussions, or spoken or written words, the electronic transmission systems or the telephone numbers to be tracked down, tapped, listened to, intercepted, and recorded, and their locations, or if the person or persons suspected of committing any of the crimes defined and penalized under the provisions of this Act, are not fully known, such person or persons shall be the subject of continuous surveillance. b. The identity of the law enforcement agent or military personnel, including the individual identity of the members of his team, judicially authorized to undertake surveillance activities. c. The offense or offenses committed, or being committed, or sought to be prevented, and d. The length of time within which the authorization shall be used or carried out. Section 19. Effective period of judicial authorization. Any authorization granted by the Court of Appeals, pursuant to Section 17 of this Act, shall only be effective, for the length of time specified in the written order of the authorizing division of the Court of Appeals, which shall not exceed a period of 60 days, from the date of receipt of the written order by the applicant law enforcement agent or military personnel. The authorizing division of the Court of Appeals may extend or renew the said authorization to a non-extendable period, which shall not exceed 30 days from the expiration of the original period, provided that the issuing court is satisfied that such extension or renewal is in the public interest, and provided further that the ex parte application for extension or renewal, which must be filed by the original applicant, has been duly authorized in writing by the ATC. In case of death of the original applicant, or in case he or she is physically disabled, to file the application for extension or renewal, the one next in rank to the original applicant, among the members of the team named in the original written order, shall file the application for extension or renewal. Provided finally that, the applicant law enforcement agent or military personnel, shall have 30 days, after the termination of the period granted by the Court of Appeals, as provided in the preceding paragraphs within which to file the appropriate case, before the Public Prosecutor's Office for any violation of this Act. For purposes of this provision, the issuing court shall require the applicant law enforcement or military official to inform the court, after the lapse of the 30-day period, of the fact that an appropriate case for violation of this Act has been filed with the Public Prosecutor's Office. Section 20. Custody of intercepted and recorded communications. All tapes, disks, other storage devices, recordings, notes, memoranda, summaries, excerpts, and all copies thereof obtained under the judicial authorization granted by the Court of Appeals, shall within 48 hours after the expiration of the period fixed in the written order, or the extension or renewal granted thereafter, be deposited with the issuing court, in a sealed envelope or sealed package, as the case may be, and shall be accompanied by a joint affidavit of the applicant law enforcement agent, or military personnel, and the members of his or her team. In case of death of the applicant, or in case he or she is physically disabled, to execute the required affidavit, the one next in rank to the applicant among the members of the team, named in the written order of the authorizing division of the Court of Appeals, shall execute with the members of the team, that required affidavit. It shall be unlawful for any person, law enforcement agent, or military personnel, or any custodian of the tapes, discs, other storage devices, recordings, notes, memoranda, summaries, excerpts and all copies thereof, to remove, delete, expunge, incinerate, shred or destroy in any manner, the items enumerated above in whole or in part, under any pretext whatsoever. Any person who removes, deletes, expunges, incinerates, shreds, or destroys the items enumerated above, shall suffer the penalty of imprisonment of 10 years. Section 21. Contents of Joint Affidavit. The joint affidavit of the law enforcement agent, or military personnel, shall state a. The number of tapes, discs, and recordings that have been made. b. The dates and times covered by each of such tapes, discs, and recordings, and c. The chain of custody, or the list of persons who had possession or custody over the tapes, discs and recordings. The joint affidavit shall also certify under oath that no duplicates or copies of the whole, or any part of any of such tapes, discs, other storage devices, recordings, notes, memoranda, summaries, or excerpts, have been made, or, if made, that all such duplicates and copies are included in the sealed envelope or sealed package, as the case may be, deposited with the authorizing division of the Court of Appeals. It shall be unlawful for any person, law enforcement agent, or military personnel, to omit or exclude from the joint affidavit any item or portion thereof mentioned in this section. Any person, law enforcement agent, or military officer, who violates any of the acts proscribed in the preceding paragraph, shall suffer the penalty of imprisonment of 10 years. Section 22. Disposition of deposited materials. The sealed envelope, or sealed package and the contents thereof, referred to in Section 20 of this Act, shall be deemed and are hereby declared classified information. The sealed envelope, or sealed package, shall not be opened, disclosed, or used as evidence, unless authorized by a written order of the authorizing division of the Court of Appeals, which written order shall be granted only upon a written application of the Department of Justice or DOJ, duly authorized in writing by the ATC to file the application, with proper written notice to the person whose conversation, communication, message, discussion or spoken or written words have been the subject of surveillance, monitoring, recording and interception, to open, reveal, divulge, and use the contents of the sealed envelope, or sealed package as evidence. The written application, with notice to the party concerned, for the opening, replaying, disclosing, or using as evidence of the sealed package, or the contents thereof, shall clearly state the purpose or reason for its opening, replaying, disclosing, or its being used as evidence. Violation of this section shall be penalized by imprisonment of 10 years. Section 23. Evidentiary value of deposited materials. Any listened to, intercepted, and recorded communications, messages, conversations, discussions, or spoken or written words, or any part or parts thereof, or any information or fact contained therein, including their existence, content, substance, purport, effect, or meaning, which been secured in violation of the pertinent provisions of this Act, shall be inadmissible, and cannot be used as evidence against anybody, in any judicial, quasi-judicial, legislative, or administrative investigation, inquiry, proceeding, or hearing. Section 24. Unauthorized or malicious interceptions and/or recordings. Any law enforcement agent, or military personnel, who conducts surveillance activities, without a valid judicial authorization pursuant to Section 17 of this Act, shall be guilty of this offense, and shall suffer the penalty of imprisonment of 10 years. All information that have been maliciously procured, should be made available to the aggrieved party. Section 25. Designation of terrorist individual, groups of persons, organizations or associations. Pursuant to our obligations under United Nations Security Council Resolution or UNSCR No. 1373, the ATC shall automatically adopt the United Nations Security Council Consolidated List of designated individuals, group of persons, organizations, or associations designated in or identified as a terrorist, one who finances terrorism, or a terrorist organization or group. Request for designations by other jurisdictions, or supranational jurisdictions, may be adopted by the ATC, after determination that the proposed designee meets the criteria for designation of UNSCR No. 1373. The ATC may designate an individual, groups of persons, organization, or association, whether domestic or foreign, upon a finding of probable cause, that the individual, groups of persons, organization, or association commit, or attempt to commit, or conspire in the commission of the acts defined and penalized under Sections 4, 5, 6, 7, 8, 9, 10, 11 and 12 of this Act. The assets of the designated individual, groups of persons, organization, or association above mentioned, shall be subject to the authority of the Anti-Money Laundering Council or AMLC, to freeze pursuant to Section 11 of Republic Act No. 1016-8. The designation shall be without prejudice to the proscription of terrorist organizations, associations, or groups of persons under Section 26 of this Act. Section 26. Proscription of terrorist organizations, association, or group of persons. Any group of persons, organization, or association, which commits any of the acts defined and penalized under Sections 4, 5, 6, 7, 8, 9, 10, 11 and 12 of this Act, or organized for the purpose of engaging in terrorism, shall, upon application of the DOJ, before the authorizing division of the Court of Appeals, with due notice and opportunity to be heard, given to the group of persons, organization or association, be declared as a terrorist, and outlawed group of persons, organization or association, by the said court. The application shall be filed, with an urgent prayer for the issuance of a preliminary order of proscription. No application for prescription shall be filed without the authority of the ATC, upon the recommendation of the National Intelligence Coordinating Agency or NICA. Section 27. Preliminary Order of Proscription. Where the court has determined that probable cause exists, on the basis of the verified application, which is sufficient in form and substance, that the issuance of an order of proscription is necessary to prevent the commission of terrorism, he or she shall, within 72 hours from the filing of the application, issue a preliminary order of proscription, declaring that the respondent is a terrorist, and an outlawed organization, or association within the meaning of Section 26 of this Act. The court shall immediately commence and conduct continuous hearings, which should be completed within 6 months from the time the application has been filed, to determine whether a. The preliminary order of proscription should be made permanent. b. A permanent order of proscription should be issued, in case no preliminary order was issued, or c. A preliminary order of proscription should be lifted. It shall be the burden of the applicant to prove that the respondent is a terrorist, and an outlawed organization, or association within the meaning of Section 26 of this Act, before the court issues an order of proscription whether preliminary or permanent. The permanent order of proscription herein granted, shall be published in a newspaper of general circulation. It shall be valid for a period of 3 years, after which, a review of such order shall be made, and if circumstances warrant, the same shall be lifted. Section 28. Request to proscribe from foreign jurisdictions and supranational jurisdictions. Consistent with the national interest, all requests for proscription made by another jurisdiction or supranational jurisdiction shall be referred by the Department of Foreign Affairs or DFA to the ATC to determine, with the assistance of the NICA, if proscription under Section 26 of this Act is warranted. If the request for proscription is granted, the ATC shall correspondingly commence proscription proceedings through the DOJ. Section 29. Detention without judicial warrant of arrest. The provisions of Article 125 of the Revised Penal Code to the contrary notwithstanding, any law enforcement agent, or military personnel, who, having been duly authorized in writing by the ATC, has taken custody of a person suspected of committing any of the acts defined and penalized under Sections 4, 5, 6, 7, 8, 9, 10, 11 and 12 of this Act, shall, without incurring any criminal liability, for delay in the delivery of detained persons to the proper judicial authorities, deliver said suspected person, to the proper judicial authority, within a period of 14 calendar days, counted from the moment the said suspected person has been apprehended or arrested, detained, and taken into custody by the law enforcement agent or military personnel. The period of detention may be extended to a maximum period of 10 calendar days, if it is established that 1. Further detention of the person or persons is necessary to preserve evidence related to terrorism, or complete the investigation. 2. Further detention of the person or persons is necessary to prevent the commission of another terrorism, and 3. The investigation is being conducted properly and without delay. Immediately after taking custody of a person suspected of committing terrorism, or any member of a group of persons, organization, or association proscribed under Section 26 hereof, the law enforcement agent, or military personnel, shall notify in writing the judge of the court nearest the place of apprehension or arrest, of the following facts. A. The time, date, and manner of arrest. B. The location or locations of the detained suspects and C. The physical and mental condition of the detained suspect or suspects. The law enforcement agent, or military personnel, shall likewise furnish the ATC and the Commission on Human Rights or CHR, of the written notice given to the judge. The head of the detaining facility shall ensure that the detained suspect is informed of his or her rights as a detainee, and shall ensure access to the detainee by his or her counsel or agencies, and entities authorized by law to exercise visitorial powers over detention facilities. The penalty of imprisonment of 10 years shall be imposed upon the police or law enforcement agent, or military personnel, who fails to notify any judge as provided in the preceding paragraph. Section 30. Rights of a person under custodial detention. The moment a person charged with, or suspected of committing any of the acts defined and penalized under Sections 4, 5, 6, 7, 8, 9, 10, 11 and 12 of this Act is apprehended, or arrested and detained, he or she shall forthwith be informed, by the arresting law enforcement agent or military personnel, to whose custody the person concerned is brought, of his or her right. A. To be informed of the nature and cause of his or her arrest, to remain silent, and to have competent and independent counsel preferably of his or her choice. If the person cannot afford the services of counsel of his or her choice, the law enforcement agent, or military personnel concerned, shall immediately contact the Free Legal Assistance Unit of the Integrated Bar of the Philippines or IBP or the Public Attorney's Office or PAO. It shall be the duty of the Free Legal Assistance Unit of the IBP or the PAO thus contacted, to immediately visit the person or persons detained, and provide him or her with legal assistance. These rights cannot be waived, except in writing, and in the presence of his or her counsel of choice. B. Informed of the cause or causes of his or her detention, in the presence of his legal counsel. C. Allowed to communicate freely with his or her legal counsel, and to confer with them at any time without restriction. D. Allowed to communicate freely and privately, without restrictions with the members of his or her family, or with his or her nearest relatives, and to be visited by them, and E. Allowed freely to avail of the service of a physician or physicians of choice. Section 31. Violation of the rights of a detainee. The penalty of imprisonment of 10 years shall be imposed upon any law enforcement agent, or military personnel, who has violated the rights of persons under their custody, as provided for in Sections 29 and 30 of this Act. Unless the law enforcement agent or military personnel, who violated the rights of a detainee or detainees as stated above is duly identified, the same penalty shall be imposed on the head of the law enforcement unit or military unit having custody of the detainee, at the time the violation was done. Section 32. Official Custodial Logbook and its contents. The law enforcement custodial unit, in whose care and control the person suspected of committing any of the acts defined and penalized under Sections 4, 5, 6, 7, 8, 9, 10, 11 and 12 of this Act, has been placed under custodial arrest and detention, shall keep a securely and orderly maintained official logbook, which is hereby declared as a public document, and open to and made available for the inspection and scrutiny of the lawyer of the person under custody, or any member of his or her family, or relative by consanguinity or affinity within the fourth civil degree, or his or her physician, at any time of the day or night, subject to reasonable restrictions by the custodial facility. The logbook shall contain a clear and concise record of a. The name, description, and address of the detained person. b. The date and exact time of his or her initial admission for custodial arrest and detention. c. The name and address of the physician or physicians, who examined him or her physically and medically. d. The state of his or her health and physical condition at the time of his or her initial admission for custodial detention. e. The date and time of each removal of the detained person from his or herself for interrogation, or for any purpose. f. The date and time of his or her return to his or her cell. g. The name and address of the physician or physicians, who physically and medically examined him or her after each interrogation. h. A summary of the physical and medical findings on the detained person, after each of such interrogation. I. The names and addresses of his or her family members and nearest relatives, if any and if available. j. The names and addresses of persons, who visit the detained person. k. The date and time of each of such visit. l. The date and time of each request of the detained person to communicate and confer, with his or her legal counsel or counsels. m. The date and time of each visit, and date and time of each departure of his or her legal counsel or counsels, and n. All other important events bearing on, and all relevant details regarding the treatment of the detained person, while under custodial arrest and detention. The said law enforcement custodial unit shall, upon demand of the aforementioned lawyer, or members of the family, or relatives within the fourth civil degree of consanguinity, or affinity of the person under custody, or his or her physician, issue a certified true copy of the entries of the logbook, relative to the concerned detained person, subject to reasonable restrictions by the custodial facility. This certified true copy may be attested by the person who has custody of the logbook, or who allowed the party concerned to scrutinize it, at the time the demand for the certified true copy is made. The law enforcement custodial unit, who fails to comply with the preceding paragraphs to keep an official logbook, shall suffer the penalty of imprisonment of 10 years. Section 33. No torture or coercion in investigation and interrogation. The use of torture, and other cruel, inhumane and degrading treatment or punishment, as defined in Sections 4 and 5 of Republic Act No. 9745, otherwise known as the Anti-Torture Act of 2009, at any time during the investigation, or interrogation of a detained suspected terrorist, is absolutely prohibited, and shall be penalized under said law. Any evidence obtained from said detained person, resulting from such treatment, shall be, in its entirety, inadmissible, and cannot be used as evidence in any judicial, quasi-judicial, legislative, or administrative investigation, inquiry, proceeding, or hearing. Section 34. Restriction on the right to travel. Prior to the filing of an information for any violation of Sections 4, 5, 6, 7, 8, 9, 10, 11 and 12 of this Act, the investigating prosecutor shall apply for the issuance of a precautionary hold departure order or PHDO, against the respondent upon a preliminary determination of probable cause in the proper regional trial court. Upon the filing of the information, regarding the commission of any acts defined and penalized under the provisions of this Act, the prosecutor shall apply with the court having jurisdiction, for the issuance of a hold departure order or HDO against the accused. The said application shall be accompanied by the complaint affidavit and its attachments, personal details, passport number, and a photograph of the accused, if available. In cases where evidence of guilt is not strong, and the person charged is entitled to bail and is granted the same, the court, upon application by the prosecutor, shall limit the right of travel of the accused to within the municipality or city where he or she resides, or where the case is pending, in the interest of national security and public safety, consistent with Article 3, Section 6 of the Constitution. The court shall immediately furnish the DOJ and the Bureau of Immigration or BI with a copy of said order. travel outside of said municipality or city, without the authorization of the court, shall be deemed a violation of the terms and conditions of his or her bail, which shall be forfeited as provided under the rules of court. He or she may also be placed under house arrest, by order of the court, at his or her usual place of residence. While under house arrest, he or she may not use telephones, cell phones, emails, computers, the internet, or other means of communications, with people outside the residence, until otherwise ordered by the court. If the evidence of guilt is strong, the court shall immediately issue an HDO, and direct the DFA to initiate the procedure for the cancellation of the passport of the accused. The restrictions above mentioned, shall be terminated upon the acquittal of the accused, or of the dismissal of the case filed against him or her, or earlier upon the discretion of the court on motion of the prosecutor or of the accused. Section 35. Anti-Money Laundering Council authority to investigate, inquire into and examine bank deposits. Upon the issuance by the court of a preliminary order of proscription, or in case of designation under Section 25 of this Act, the AMLC, either upon its own initiative, or at the request of the ATC, is hereby authorized to investigate a. Any property or funds, that are in any way related to financing of terrorism, as defined and penalized under Republic Act No. 1016-8, or violation of Sections 4, 6, 7, 10, 11 or 12 of this Act, and b. Property or funds of any person or persons, in relation to whom there is probable cause to believe, that such person or persons are committing, or attempting, or conspiring to commit, or participating in, or facilitating the financing of the aforementioned sections of this Act. The AMLC may also enlist the assistance of any branch, department, bureau, office, agency or instrumentality of the government, including government-owned and controlled corporations, in undertaking measures to counter the financing of terrorism, which may include the use of its personnel, facilities and resources. For purposes of this section, and notwithstanding the provisions of Republic Act No. 1405, otherwise known as the Law on Secrecy of Bank Deposits, as amended, Republic Act No. 6426, otherwise known as the Foreign Currency Deposit Act of the Philippines, as amended, Republic Act No. 8791, otherwise known as the General Banking Law of 2000 and other laws, the AMLC is hereby authorized to inquire into, or examine deposits and investments with any banking institution, or non-bank financial institution and their subsidiaries and affiliates, without a court order. Section 36. Authority to freeze. Upon the issuance by the court, of a preliminary order of proscription, or in case of designation under Section 25 of this Act, the AMLC, either upon its own initiative, or request of the ATC, is hereby authorized to issue an ex parte order, to freeze without delay. A. Any property or funds, that are in any way related to financing of terrorism, as defined and penalized under Republic Act No. 1016-8, or any violation of Sections 4, 5, 6, 7, 8, 9, 10, 11 or 12 of this Act, and b. Property or funds of any person or persons, in relation to whom there is probable cause to believe, that such person or persons are committing, or attempting, or conspiring to commit, or participating in, or facilitating the financing of the aforementioned sections of this Act. The freeze order shall be effective for a period not exceeding 20 days. Upon a petition filed by the AMLC, before the expiration of the period, the effectivity of the freeze order may be extended up to a period not exceeding 6 months, upon order of the Court of Appeals. Provided that, the 20-day period shall be told upon filing of a petition, to extend the effectivity of the freeze order. Notwithstanding the preceding paragraphs, the AMLC, consistent with the Philippines' international obligations, shall be authorized to issue a freeze order, with respect to property or funds, of a designated organization, association, group or any individual, to comply with binding terrorism-related resolutions, including UNSCR No. 1373 pursuant to Article 41 of the Charter of the UN. Said freeze order shall be effective, until the basis for the issuance thereof shall have been lifted. During the effectivity of the freeze order, an aggrieved party may, within 20 days from issuance, file with the Court of Appeals a petition, to determine the basis of the freeze order, according to the principle of effective judicial protection. Provided that the person whose property or funds have been frozen may withdraw such sums as the AMLC determines to be reasonably needed for monthly family needs and sustenance, including the services of counsel, and the family medical needs of such person. However, if the property or funds, subject of the freeze order under the immediately preceding paragraph are found to be in any way related to financing of terrorism, as defined and penalized under Republic Act No. 1016-8, or any violation of Sections 4, 5, 6, 7, 8, 9, 10, 11 or 12 of this Act, committed within the jurisdiction of the Philippines, said property or funds shall be the subject of civil forfeiture proceedings, as provided under Republic Act No. 1016-8. Section 37. Malicious examination of a bank or a financial institution. Any person who maliciously, or without authorization, examines deposits, placements, trust accounts, assets, or records in a bank or financial institution, in relation to Section 36 hereof, shall suffer the penalty of 4 years of imprisonment. Section 38. Safe Harbor. No administrative, criminal or civil proceedings shall lie against any person acting in good faith, when implementing the targeted financial sanctions as provided under pertinent United Nations security resolutions. Section 39. Bank officials and employees defying a court authorization. An employee, official, or a member of the board of directors of a bank or financial institution, who after being duly served with the written order of authorization from the Court of Appeals, refuses to allow the examination of the deposits, placements, trust accounts, assets, and records of a terrorist, or an outlawed group of persons, organization or association, in accordance with Sections 25 and 26 hereof, shall suffer the penalty of imprisonment of 4 years. Section 40. Immunity and protection of government witnesses. The immunity and protection of government witnesses shall be governed by the provisions of Republic Act No. 6981, otherwise known as the Witness Protection, Security and Benefits Act. Section 41. Penalty for unauthorized revelation of classified materials. The penalty of imprisonment of 10 years shall be imposed upon any person, law enforcement agent or military personnel, judicial officer or civil servant who, not being authorized by the Court of Appeals to do so, reveals in any manner or form any classified information under this Act. The penalty imposed herein is without prejudice, and in addition to any corresponding administrative liability the offender may have incurred for such acts. Section 42. Infidelity in the custody of detained persons. Any public officer, who has direct custody of a detained person under the provisions of this Act, and, who, by his deliberate act, misconduct or inexcusable negligence, causes or allows the escape of such detained person, shall be guilty of an offense, and shall suffer the penalty of 10 years of imprisonment. Section 43. Penalty for furnishing false evidence, forged document, or spurious evidence. The penalty of imprisonment of 6 years shall be imposed upon any person who knowingly furnishes false testimony, forged document, or spurious evidence in any investigation or hearing conducted in relation to any violations under this Act. Section 44. Continuous trial. In cases involving crimes defined and penalized under the provisions of this Act, the judge concerned shall set the case for continuous trial on a daily basis from Monday to Thursday, or other short-term trial calendar, to ensure compliance with the accused's right to speedy trial. Section 45. Anti-Terrorism Council. An Anti-Terrorism Council or ATC is hereby created. The members of the ATC are 1. The Executive Secretary, who shall be its chairperson. 2. The National Security Advisor, who shall be its vice chairperson, and 3. The Secretary of Foreign Affairs. 4. The Secretary of National Defense. 5. The Secretary of the Interior and Local Government. 6. The Secretary of Finance. 7. The Secretary of Justice. 8. The Secretary of Information and Communications Technology, and 9. The Executive Director of the Anti-Money Laundering Council or AMLC Secretariat as its other members. The ATC shall implement this Act, and assume the responsibility for the proper and effective implementation of the policies of the country against terrorism. The ATC shall keep records of its proceedings and decisions. All records of the ATC shall be subject to such security classifications as the ATC may, in its judgment and discretion, decide to adopt to safeguard the safety of the people, the security of the Republic, and the welfare of the nation. The NICA shall be the Secretariat of the ATC. The ATC shall define the powers, duties, and functions of the NICA as Secretariat of the ATC. The Anti-Terrorism Council Program Management Center or ATC-PMC is hereby institutionalized as the main coordinating and program management arm of the ATC. The ATC shall define the powers, duties, and functions of the ATC-PMC, the Department of Science and Technology or DOST, the Department of Transportation or DOTR, the Department of Labor and Employment or DOLE, the Department of Education or DepEd, the Department of Social Welfare and Development or DSWD, the Presidential Advisor for Peace, Reunification and Unity or PAPRU, formerly PAPP, the Bangsamoro Autonomous Region in Muslim Mindanao or BARMM, the National Bureau of Investigation or NBI, the BI, the Office of Civil Defense or OCD, the Intelligence Service of the Armed Forces of the Philippines or ISAFP, the Philippine Center on Transnational Crimes or PCTC, the Philippine National Police or PNP Intelligence and Investigative Elements, the Commission on Higher Education or CHED, and the National Commission on Muslim Filipinos or NCMF, shall serve as support agencies of the ATC. The ATC shall formulate and adopt comprehensive, adequate, efficient, and effective plans, programs, or measures, to prevent, counter, suppress, or eradicate the commission of terrorism in the country, and to protect the people from such acts. In pursuit of said mandate, the ATC shall create such focus programs, to prevent and counter terrorism as necessary, to ensure the counterterrorism operational awareness of concerned agencies, to conduct legal action, and to pursue legal and legislative initiatives to counter terrorism, prevent and stem terrorist financing, and to ensure compliance with international commitments to counter terrorism-related protocols and bilateral and/or multilateral agreements, and identify the lead agency for each program, such as A. Preventing and Countering Violent Extremism Program. The program shall address the conditions conducive to the spread of terrorism, which include, among others, ethnic, national, and religious discrimination, socioeconomic disgruntlement, political exclusion, dehumanization of victims of terrorism, lack of good governance, and prolonged unresolved conflicts, by winning the hearts and minds of the people, to prevent them from engaging in violent extremism. It shall identify, integrate, and synchronize all government and non-government initiatives and resources, to prevent radicalization and violent extremism, thus reinforce and expand an aftercare program. B. Preventing and Combating Terrorism Program. The program shall focus on denying terrorist groups access to the means to carry out attacks to their targets, and formulate response to its desired impact, through decisive engagements. The program shall focus on operational activities, to disrupt and combat terrorism activities and attacks, such as curtailing, recruitment, propaganda, finance and logistics, the protection of potential targets, the exchange of intelligence with foreign countries, and the arrest of suspected terrorists. C. International Affairs and Capacity Building Program. The program shall endeavor to build the state's capacity to prevent and combat terrorism by strengthening the collaborative mechanisms between and among ATC members, and support agencies and facilitate cooperation among relevant stakeholders, both local and international, in the battle against terrorism, and D. Legal Affairs Program. The program shall ensure respect for human rights, and adherence to the rule of law, as the fundamental basis of the fight against terrorism. It shall guarantee compliance with the same, as well as with international commitments to counter terrorism-related protocols and bilateral and/or multilateral agreements. Nothing herein shall be interpreted to empower the ATC to exercise any judicial or quasi-judicial power or authority. Section 46. Functions of the Council. In pursuit of its mandate in the previous section, the ATC shall have the following functions, with due regard for the rights of the people as mandated by the Constitution and pertinent laws. A. Formulate and adopt plans, programs, and preventive and countermeasures against terrorists and terrorism in the country. B. Coordinate all national efforts to suppress and eradicate terrorism in the country, and mobilize the entire nation against terrorism, prescribed in this Act. C. Direct the speedy investigation and prosecution of all persons detained or accused for any crime defined and penalized under this Act. D. Monitor the progress of the investigation and prosecution of all persons accused and or detained for any crime defined and penalized under the provisions of this Act. E. Establish and maintain comprehensive database information systems on terrorism, terrorist activities, and counterterrorism operations. F. Enlist the assistance of, and file the appropriate action with the AMLC, to freeze and forfeit the funds, bank deposits, placements, trust accounts, assets and property of whatever kind and nature belonging 1. To a person suspected of, or charged with alleged violation of any of the acts defined and penalized under Sections 4, 5, 6, 7, 8, 9, 10, 11 and 12 of this Act. 2. Between members of a judicially declared and outlawed terrorist organization or association, as provided in Section 26 of this Act. 3. To designated persons defined under Section 3E of R.A. No. 1016-8. 4. To an individual member of such designated persons, or 5. Any individual, organization, association or group of persons proscribed under Section 26 hereof. G. Grant monetary rewards and other incentives to informers who give vital information, leading to the apprehension, arrest, detention, prosecution, and conviction of person or persons found guilty for violation of any of the acts defined and penalized under Sections 4, 5, 6, 7, 8, 9, 10, 11 and 12 of this Act. Provided that, no monetary reward shall be granted to informants, unless the accused's demurrer to evidence has been denied, or the prosecution has rested its case, without such demurrer having been filed. H. Establish and maintain coordination with, and the cooperation and assistance of other states, jurisdictions, international entities, and organizations, in preventing and combating international terrorism. I. Take action on relevant resolutions issued by the UN Security Council, acting under Chapter 7 of the UN Charter, and consistent with the national interest, take action on foreign requests, to designate terrorist individuals, associations, organizations or group of persons. J. Take measures, to prevent the acquisition and proliferation by terrorists, of weapons of mass destruction. K. Lead in the formulation, and implementation of a national strategic plan, to prevent and combat terrorism. L. Request the Supreme Court, to designate specific divisions of the Court of Appeals, or regional trial courts, to handle all cases involving the crimes defined and penalized under this Act. M. Require other government agencies, offices, and entities, and officers and employees, and non-government organizations, private entities, and individuals to render assistance to the ATC in the performance of its mandate, and N. Investigate motu proprio, or upon complaint, any report of abuse, malicious application, or improper implementation by any person of the provisions of this Act.
Section 47. Commission on Human Rights, CHR. The CHR shall give the highest priority to the investigation and prosecution of violations of civil and political rights of persons, in relation to the implementation of this Act.
Section 48. Ban on extraordinary rendition. No person suspected or convicted of any of the crimes defined and penalized under the provisions of Sections 4, 5, 6, 7, 8, 9, 10, 11 or 12 of this Act, shall be subjected to extraordinary rendition to any country. Section 49. Extra-territorial Application. Subject to the provision of any treaty, of which the Philippines is a signatory, and to any contrary provision of any law of preferential application, the provisions of this Act shall apply. A. To a Filipino citizen or national, who commits any of the acts defined and penalized under Sections 4, 5, 6, 7, 8, 9, 10, 11 and 12 of this Act, outside the territorial jurisdiction of the Philippines. B. To individual persons who, although physically outside the territorial limits of the Philippines, commit any of the crimes mentioned in paragraph A hereof, inside the territorial limits of the Philippines. C. To individual persons who, although physically outside the territorial limits of the Philippines, commit any of the said crimes mentioned in paragraph A hereof, on board Philippine ship, or Philippine airship. D. To individual persons, who commit any of said crimes mentioned in paragraph A hereof, within any embassy, consulate, or diplomatic premises, belonging to, or occupied by the Philippine government in an official capacity. E. To individual persons who, although physically outside the territorial limits of the Philippines, commit said crimes mentioned in paragraph A hereof, against Philippine citizens, or persons of Philippine descent, where their citizenship or ethnicity was a factor in the commission of the crime, and F. To individual persons who, although physically outside the territorial limits of the Philippines, commit said crimes directly against the Philippine government. In case of an individual who is neither a citizen, or a national of the Philippines, who commits any of the crimes mentioned in paragraph A hereof, outside the territorial limits of the Philippines shall exercise jurisdiction only, when such individual enters, or is inside the territory of the Philippines, provided that, in the absence of any request for extradition, from the state where the crime was committed, or the state where the individual is a citizen or national, or the denial thereof, the ATC shall refer the case to the BI for deportation, or to the DOJ for prosecution, in the same manner as if the act constituting the offense had been committed in the Philippines. Section 50. Joint Oversight Committee. Upon the effectivity of this Act, a Joint Congressional Oversight Committee is hereby constituted. The committee shall be composed of 12 members, with the chairperson of the Committee on Public Order of the Senate and the House of Representatives as members, and 5 additional members from each House to be designated by the Senate President and the Speaker of the House of Representatives, respectively. The minority shall be entitled to a pro rata representation, but shall have at least 2 representatives in the committee. In the exercise of its oversight functions, the Joint Congressional Oversight Committee shall have the authority to summon law enforcement, or military officers and the members of the ATC to appear before it, and require them to answer questions, and submit written reports of the acts they have done in the implementation of this Act, and render an annual report to both houses of Congress as to its status and implementation. Section 51. Protection of most vulnerable groups. There shall be due regard for the welfare of any suspects, who are elderly, pregnant, persons with disability, women and children while they are under investigation, interrogation or detention. Section 52. Management of persons charged under this Act. The Bureau of Jail Management and Penology or BJMP, and the Bureau of Corrections or BUCOR, shall establish a system of assessment and classification, for persons charged for committing terrorism and preparatory acts punishable under this Act. Said system shall cover the proper management, handling, and interventions for said persons detained. Persons charged under this Act shall be detained in existing facilities of the BJMP and the BUCOR. Section 53. Trial of persons charged under this Act. Any person charged for violations of Sections 4, 5, 6, 7, 8, 9, 10, 11 or 12 of this Act, shall be tried in special courts created for this purpose. In this regard, the Supreme Court shall designate certain branches of the regional trial courts, as anti-terror courts whose jurisdiction is exclusively limited to try violations of the above-mentioned provisions of this Act. Persons charged under the provisions of this Act, and witnesses, shall be allowed to remotely appear, and provide testimonies through the use of video conferencing, and such other technology now known or may hereafter be known to science, as approved by the Supreme Court. Section 54. Implementing Rules and Regulations. The ATC and the DOJ, with the active participation of police and military institutions, shall promulgate the rules and regulations, for the effective implementation of this Act within 90 days after its effectivity. They shall also ensure the full dissemination of such rules and regulations, to both houses of Congress, and all officers and members of various law enforcement agencies. Section 55. Separability Clause. If for any reason, any part or provision of this Act, is declared unconstitutional or invalid, the other parts or provisions hereof, which are not affected thereby, shall remain and continue to be in full force and effect. Section 56. Repealing Clause. Republic Act No. 9372, otherwise known as the Human Security Act of 2007, is hereby repealed. All laws, decrees, executive orders, rules or regulations or parts thereof, inconsistent with the provisions of this Act, are hereby repealed, amended, or modified accordingly. Section 57. Saving Clause. All judicial decisions and orders issued, as well as pending actions relative to the implementation of Republic Act No. 9372, otherwise known as the Human Security Act of 2007, prior to its repeal, shall remain valid and effective. Section 58. Effectivity. This Act shall take effect 15 days after its complete publication in the Official Gazette, or in at least 2 newspapers of general circulation. This Act was passed by the Senate of the Philippines as Senate Bill No. 1083 on February 26, 2020, and adopted by the House of Representatives as an amendment to House Bill No. 6875 on June 5, 2020, respectively. It was approved on July 3, 2020.